Elizabeth from Gannett and Associates speaking. Elizabeth from Gannett and Associates speaking. I can't hear you, unfortunately. Can you hear me? I can't hear you, unfortunately. I'm happy to provide my office number if that's more suitable. I just can't hear anything from your end. I'll hang up now, given I can't hear you. Thanks very much. Elizabeth from Gannett and Associates speaking. Thank you. Elizabeth from Gannett and Associates speaking. Just for the record, I can't hear you, but I'm assuming that's because you're on mute. Thanks, Mark.
All stand. Coronial Court's now in session. Please be seated.
Mr. McMahon.
Good morning, Your Honour. May I just raise a point, Your Honour? It hasn't been raised in this last week or so, but it might be a good time to raise it now. It's just on behalf of my client and the broader Aboriginal community outside. As everybody here knows, these proceedings are being live streamed to Yuendamu, Punya and possibly elsewhere, well definitely elsewhere because people from all over Australia are sending us messages. And it goes without saying that the events we're about to discuss today, in particular in the next 2 days, are events which were traumatising for the Yuendamu community and their families, extended families, and they continue to be traumatising. Your Honour will be aware, as everyone here will be aware, that some members of the community have come into court to watch proceedings in the last week. Not very many, and there's a room outside that they can go to if the community wishes to, but not many have done that. Most of the community and families are on the lawn outside, watching us and trying to follow what's going on. Any observant person would have noticed the lawyers speaking to them lunchtime and after court every day as we're trying to explain the issues that have arisen and so on. So I just mentioned that to put it in everyone's mind that what's going to happen today and tomorrow and the next day, we lawyers, of course, understand the propriety and appropriateness of what happens in the court, but it is going to be re-traumatising to visit these events and to revisit these events. And I thought it might be appropriate to acknowledge, thank you for the indulgence of letting me do this, Your Honour, I thought it might be appropriate to acknowledge the presence of all of those people who have come to sit on the lawn for the last week, and just to remind ourselves that we ought to be attentive to the fact that what's unfolding in the next few days particularly will be re-traumatising for my clients and the community of Yuendamu. And that's probably all I need to say about the matter, Your Honour. It's just seemed an appropriate time given the issues that we're about to deal with, just to be mindful of it.
Thank you, Mr. McMahon. I appreciate that reminder. Of course, those of us who are in Alice Springs are well aware that there is a very extensive community and family who continue to be respectful and attentive to the inquest as it reaches its closing stages. And I acknowledge that they, although they are not in the courtroom, are very much a part of the proceedings that are continuing this week. Thank you for reminding us.
Your Honour, I had intended to rise first, but I wanted to rise to thank the Northern Territory Police. Your Honour, they have at my request investigated the disturbing events of what occurred when we left this courtroom on Monday. They've also investigated a threat against me personally that I received yesterday. And I'm pleased to say that they've resolved both matters to my satisfaction. And I want to thank them for their prompt efforts in resolving both those matters.
Yes, thanks, Mr. Abbott. I'm glad that that's been resolved.
Your Honour, may I just acknowledge the families on the lawn include the Walker, Lane, Robertson, Brown, Oldfield and Williams families.
Thank you.
Your Honour, I might also put on the record that you, as Your Honour knows from the outset, we have attempted to have interpreters available for family members, both literature and Walpole interpreters. We're very fortunate to have our literature interpreter here in the courtroom. Despite our best endeavours over a long period of time leading up to this week, because of the scarcity of Walpole interpreters, we have not been able to find a Walpole interpreter. That makes it even more difficult for families to fully engage with and understand the process. On previous occasions, we've been very privileged, as Your Honour knows, to have Valda Nakarula Shannon. She wasn't available, sadly, for this week. We started the inquest with a two-way learning session, as Your Honour will recall, with Valda Nakarula Shannon and Jodie Clarkson about deep listening and listening carefully. And we aim to make these proceedings as accessible as possible in spite of the difficulties. So I will try to keep my questions as clear as possible to minimise the risk of objection. And I might ask my learned friends to think carefully about whether objections are necessary to assist us to get through the evidence as quickly as possible. No doubt, of course, it's a difficult day for family and community. It's a difficult day for Mr. Rolfe, or it may well be, and so he should, of course, feel free to ask for any breaks that are necessary to make sure that he doesn't feel, that he feels as comfortable as possible.
Thank you.
But before we start, Your Honour, you will have noticed that Acting Commissioner, currently Deputy Commissioner Dole, has been present during these proceedings over the last week as a mark of respect to the court in order to also learn anything that needs to be learned and respond to anything to which there needs to be a response straight away.
Thank you, Dr. Freckleton. Yes, Dr. Dwyer.
Mr. Rolfe, you've had a lot of time to think carefully about the questions and answers in this inquest, haven't you? You've had a lot of time to plan the answers that you're going to.
I'm sorry, I think this is a criticism, an implied criticism of my client.
No, it's really a statement of what is obvious given the amount of time that's passed, Mr. Abbott. There's been a lengthy period of time.
It's the innuendo. You've had time to plan that I object to.
Well, it's a question then.
It's just a question. You've had a lot of time to think about this. That's fine. It's when the cross-examiner goes on to say
it's an examination. We're not in a criminal trial here. Everyone has a chance to ask questions of this witness.
It's a very cross-examination then.
There is nothing in the tone that is suggestive of anger or aggression or accusation. They are simply questions, Mr. Abbott. I don't understand how it is that you hear something that I cannot hear in the nature of the questions that are being asked.
Maybe it's the life I've spent as a defence barrister.
Dr. Dwyer, please continue.
Mr. Rolfe, you were first due to give evidence in these proceedings in November 2022. We're now in May of 2024. You have obviously... Sorry, February 2024.
Nearly.
I'll start again. You were originally scheduled to give evidence in November 2022. Kumanjayi passed away in November 2019. You've given evidence in a trial following that. We're now in February 2024. You have obviously had a lot of time to think about the answers that you are going to give in court in this inquest, correct?
Well, obviously, I'm not aware of what questions I'm going to be asked, but I've had a lot of time to think about this inquest.
And counsel assisting prepared for you and for you, the assistance of you, your lawyers and other parties, a document that is labelled MFI Triple M. It's 115 pages with multiple text messages. You read that document?
I've skimmed through some documents. I didn't read out all the documents.
Oh, you clearly turned your attention to many of the text messages that you understood you would be asked about as a result of that document being prepared.
No, I skimmed through some things.
You looked at and reminded yourself of text messages that you had sent to others that you anticipated you would be asked questions about. Is that right?
Some text messages.
You watched others give evidence in this inquest, didn't you?
I watched some evidence.
And you read the transcript of some of the witnesses who gave evidence that you were interested in. Is that right?
Yes.
When I took you to text message 521 yesterday, please have a look at that again now. I might start with 518 to give you the context. CV, someone who'd been in the IRT with you, sends a message, thanks for the chat and hand the Savo brother, really appreciate it. If you turn and look now please to 519, you write back, yeah, all good brother, always down for a chat about our weird shit, haha. That's the 14th of October. He says, this is going to sound wired, bro.
I object to this. This is the fourth time these messages have been read out. And I say enough is enough. Well, I thought today we were going to actually advance in terms of timing of the events of the 9th of November, but we've gone back to messages that have been repeated 3 times to this witness already.
Hopefully we will advance, Mr Abbott. As I understand it, there is a question arising on this text message from the answers that were given yesterday, and I am going to allow Dr Dwyer to ask that question.
Well, I don't have that understanding Your Honour has, so I can't speculate.
Well, I can speculate based on the questions and answers that have been given this morning.
I'll wait and see.
As
then,
to the
Your Honour.
relevance of reviewing a previous text message.
And your answer on that same day, the 14th of October, is, nah, I feel exactly the same, man, cut from the same cloth. I've only talked to you and Sykesy about my head, but even he doesn't get violent like us. You remember that text exchange?
Yes.
You read that prior to giving evidence in this inquest, haven't you?
Yes.
And you read the messages that you sent to Simo, one of your other colleagues, back earlier in the year in February, correct?
I'm not sure if I read those.
The text messages about boxing.
Yeah,
Remember those?
I'm not sure if I read those previously.
I want to suggest to you, Mr. Rolfe, that when you were asked questions about these messages, you initially suggested that this was about boxing in a recreational way and not about the violence in your head. And I want to give you an opportunity to reflect on that answer and to ask you if you were now mistaken when you first responded to Her Honour about those text messages.
I was not mistaken. I stand by my questions, my answers from yesterday.
Oh.
If you want to hear what you want to say, what you want me to say, then this: if I attend a job where a man has repeatedly raped his own daughter,
Oh, Mr. Rolfe.
and I'm answering the question.
That is not in answer to the question, Mr Rolfe. What's the next
It gets
question?
to the feelings
Please
of
just
violence.
answer my questions, Mr. Rolfe. When you answered that question and you said it was about boxing, you were not being honest with the court about what those messages were really about.
I was being honest. If you want to give me the answers you want, I'm happy to read them out, but I'm in the box under oath.
You crafted an answer to that question that you thought would suit your evidence best, and it is not truthful.
No, if you would let me answer the question that I was answering before, I'm happy to expand.
I don't want you to expand. I would just like you to answer the question, which is, I think you've told us, no, that's not correct. You stand by the answers that you gave yesterday.
Yes.
Okay.
In relation to the 7th of November, I asked you some questions about that yesterday. A lot of these questions were asked at trial, and Her Honour has the trial transcript. Do you understand that?
Yes.
I'm going to ask you some questions about that day. I'm not taking you to the trial transcript for any other reason than to refresh your memory. I'm not going to try and trick you about what happened in the trial on the 7th, about the 7th of November. Can you accept that?
I Except you saying it, do I believe you? Not at all.
You were on shift on that day. Can you remember the time?
On the Saturday. Sorry, which day?
7th of November.
No.
You logged onto the muster room computer and checked your emails and accessed the daily intel sheet you told us yesterday.
Yes.
You went into case log, you could see the body-worn video of Officers Hand and Smith. I'm just trying to summarise so that we get through this part of the evidence.
Yes.
You thought to yourself that what you had viewed in relation to that incident on the 6th was obviously a dangerous and volatile situation. That's what you thought.
Yes.
I asked you yesterday about the fact that you were critical of Hand and Smith, Officers Hand and Smith, and you said you were critical but understanding. Is that right?
Yes.
You weren't just critical of Hand and Smith, you were also critical of others up the chain of command who hadn't escalated that job. Is that right?
No.
Were you critical of the sergeant at the station for not escalating the job further?
I was not aware of any rank. All I knew of the two officers involved.
So the criticism you had at that time for the failure to escalate the job was of Hand and Smith, is that right?
Yes, they were the only two people I knew to be involved.
Did you think that they were downplaying the incident?
Yes.
Was this another example in your mind of hopeless bush cops?
No.
Was this an example in your mind of lazy bush cops?
Potentially, as I said, the statements weren't on the back of the job, and in Alice Springs, for example, it's an expectation that statements for jobs are done by the end of that shift. That's an expectation in Alice Springs. I was under the belief that was expectation police force wide, unless there are extreme circumstances.
Was one explanation for why it hadn't been escalated in your mind that these bush police or community police were letting the locals get away with it?
No.
I mean, that's what you texted your colleagues previously about bush police, isn't it? That they in your exchange with Mitch Hansen, for example, there was an exchange between the two of you about bush cops I'll take out the racist terms, letting the locals get away with things. That was the thrust of the exchange, wasn't it?
Yes, from him to me, yes.
And that's what you thought, didn't you? You didn't correct him on that. You thought bush cops were too soft on
No.
community members. You told us yesterday that you had no version from Officers Hand or Smith. You had no understanding of their experiences as a police officer,
Hang on, say that at the start. Can you please start again?
You had no version at that time from Officer Hand or Officer Smith.
I think he said he had some version because there was the promise entry, which was a summary.
You hadn't spoken to either of those officers.
Correct.
And that you said there were no statements on the job that you could read where they set out what was in their mind.
Correct.
You had no understanding of their experience out bush or their knowledge of Kumanjayi Walker.
Correct.
But you formed a view at the time that this was a perfect example of human fear-based reaction, freeze and flight.
Yes.
And you said yesterday you were critical of that response.
Yes, critical but understanding.
All right. I'm going to show you part of the diary entry that you did throughout the course of the trial for Spotlight. You know that program, don't you? That's a Channel 7 program.
Yes.
That asked you, did they, to video yourself speaking
Yes.
in a diary throughout the course of the trial.
Yes.
And you comment, don't you, throughout that, in those diary entries, about your response to Officers Hand and Smith
I can't recall.
and your view of the evidence that they gave.
I'll comment once you show me it.
Ms. Ward will show that to you now.
It's the night of day 3 of the court case. Today we heard from Chris Hand and Lanyon Smith. They're the boys that dealt with the axe incident on Wednesday the 6th of November, I think. That was the day, yeah, Wednesday the 6th of November before the Saturday night. It's a bit frustrating sitting in court when you know that when you're listening to these lads and you know that they're saying the wrong things or they're not telling the whole truth, and you just got to sit there silently. And you can't really correct them. And I know that there are other actually ex-police officers or current police officers sitting in the crowd that are feeling that same frustrating, but it's definitely more so for me, who has the potential to suffer the most consequences for them. But basically their evidence was that despite they did initially, they started to say that they said that they weren't in fear for their lives at all. They weren't scared when Walker attacked them with the axe. They knew he was just posturing. They didn't say those words, but that's what they were leaning towards. They knew he was just posturing. And therefore they didn't pull their firearms or anything like that. But under cross-examination, they both admitted that they froze. They were in fear for their lives, and basically they didn't abide by their training. In saying that, they did keep leaning towards the fact that bush policing is different than city policing or urban policing. And they're correct in saying that in a social aspect, bush policing is different than city policing. You might deal with situations differently, but when it comes to that life or death situation, there is no change. We are not trained differently. There's not different training methods for bush police and city police. We all get the exact same training methods, all go through the exact same training courses, and when you get sent out bush, once you apply to go out bush and get sent out bush, you don't receive any additional training. When it comes down to it, our tactics are the same, use of force training is exactly the same, and your response should be the same. What I can see from them in their response is it wasn't a response, it was a reaction. They suffered from the basic fight, flight or freeze. Chris Hand ran, that's flight. Lanyon Smith froze. That's clear as day. It wasn't a response, it was a fear-based reaction, and they are trying to justify themselves any way possible to let them sleep at night, which is understandable. But at the end of the day, when they're trying to justify themselves at my expense and the expense of the police force, because it affects the police force and their training, fuck them. So I understand their position. I understand what they did. I'm a very understandable dude, but when you're going to do it at someone else's expense, my expense, fuck them, mate. So that's me for the day. Fuck Hand and fuck Smith. Whatever.
Go on in that later with Spotlight when you interviewed by Mr. Denham to say, yeah, that's where I've said before, and I won't lie about it, I have called those two men cowards. And I don't believe they're cowards for their actions on that night, I believe they're cowards for their actions afterwards. They're cowards because they've tried to morph it to the point where that was a critical decision not to be abiding by their training or to fire their weapons or not to draw their weapons, and I think that's a lie. You went on a television program, you said fuck them about your other officers when they'd just given evidence under oath, and you went on that program again and called them cowards. Not very understanding of you, Mr. Rolfe, was it?
Well, I object to this. This is a man who's on trial for murder at the time, who's talking about his reactions.
Is there an objection to the question itself, Mr Abbott.
Yes, because the question doesn't recognise the stress that this man was under at the
Well,
time.
you'll have an opportunity to ask about that. The question is clear, it's understandable, and it's relevant to the issues. And it's relevant to the evidence that your client has given in these proceedings.
Well, my submission, Your Honour, is it is not relevant to the issue because you need to take this evidence, this transcript, on the basis of the circumstances in which these interviews were given. The man on trial for murder.
We understand the circumstances. It was clear from the way the evidence was introduced that it was some form of video diary that was being given by your client during the course of his trial, and this is his response, as I understand it, to certain evidence that was given.
That's what must be kept in mind. At all
I keep
times.
that in mind.
Thank you, Your Honour.
You heard yourself, Mr. Rolfe. You said about those officers, it wasn't a response, it was a reaction. They suffered from your basic fight, flight or freeze. And they're trying to justify themselves in any way possible. And you go on to say, fuck them. I understand their position. I understand what they did. I'm a very understandable dude. But when you're doing it at someone else's expense, my expense, fuck them, mate. So that's me for the day. Fuck Hand and fuck Smith, whatever. That's what you said on that video diary, correct?
Correct.
Officers Hand and Smith gave evidence under oath in a Supreme Court trial. You understood that, didn't you?
Yes.
They were merely witnesses in that trial. You understood that?
Yes.
They were not asked to critique what was in your mind on the 9th of November. They were asked to give evidence about what was going on for them on the 6th of November when they were dealing with Kumanjayi, correct?
Correct.
But because their evidence didn't suit you, you went on the attack in relation to both of those witnesses, didn't you?
Because their evidence, I don't believe, is true.
Do you think it's appropriate for you? At that stage, you were a serving member of the Northern Territory Police Force. You were talking about two officers who'd given evidence under oath, and you decided to go and record for a television program criticism of those officers, saying, fuck them for giving evidence that didn't suit my story at trial. Do you think it's appropriate?
Yes, because at that time I had gone through the entire paperwork of the investigation against me. I think I've made it clear that my view of that investigation was incompetent, if not malicious, and I was preparing for the potentiality that if, due to that incompetence or maliciousness, I would go to jail for 25 years, I was preparing for my truth to come out to hopefully correct the course of justice. And
you thought Chris Hand and Lanyon Swift were part of this conspiracy of incompetence, is that right?
He hasn't said it's a conspiracy.
That's a question.
Well, I think you'll need to break it into parts if you want to put
you
that.
You use the term you use the term incompetent and malicious, is that right? Incompetent or malicious. What did you think Chris Hand and Lanyon Smith had to do with that?
I believe they were not telling the truth in their evidence.
So you thought, did you, that they were not telling the truth to back up the Northern Territory Police Force in terms of its prosecution of you and the DPP, an independent statutory holder?
The narrative they told was suitable for the criminal investigation and has been continued to be suitable for this coronial, it seems.
So the answer to my question when I asked you before about whether you thought it was appropriate that you do that in a video diary for Spotlight was yes, and that remains your evidence today.
In the circumstances that I was in, with the goal of protecting myself from what I believe was a injustice, yes.
And you stand by your decision making and your manner of speech today?
I, in hindsight, would wish I'd never spoken to the media because in trial we were able to prove my innocence and the media was not required. The media was a tool that was I believe, sometimes used against me, and then sometimes I utilised the media as a tool as well. There was no need for that, and in hindsight, I wish I never did it.
You utilised media as a tool not just before the trial, you utilised it after the trial, didn't you? On a number of occasions.
Correct. As has the
Mr.
Coronial,
Rolfe,
sorry.
Mr. Rolfe, when you say about your colleagues, fuck them, fuck Han and fuck Smith, it's an example of your frank aggression and your short fuse. What do you say about that?
I disagree.
And the use of that language, which is aggressive, is a reflection of the fact that you can be aggressive in language and behaviour. What do you say about that?
I object to that.
I'll move on, I'll come back to it.
Well,
On the
you
7th of
can't ask a
November, I'll
question.
move on, I withdraw.
Sorry, she's withdrawn the question.
Right.
On the 7th of November, after you'd watched the body-worn video and formed a view that you say was critical but, quote, extremely understanding, you then took on a proactive leadership role to escalate that job. Is that correct?
I took on a proactive role.
You alerted Sergeant Kelly.
Yes.
You asked him to come and watch the videos and you had a discussion about it, correct?
Correct.
And you agreed that the incident should have been relayed up the chain of command and a higher response should have been organised.
Yes, Sergeant Kelly and I had the same opinion in that regard.
Well, who did you think it should have been relayed up the chain of command to?
I'm not sure. I believe it should have been relayed up the chain of command that evening, like the evening of the incident, to whoever high risk incidents usually gets relayed up the chain of command to, and potentially, or it should have been, ended up on TRG's desk for a risk assessment.
So it wasn't just Hand and Smith that you were critical of, was it? It was you were critical of the fact that someone else hadn't relayed it up the chain of command? Or were you critical of them for not relaying it up the chain of command?
Well, at that time, I only knew those two were involved. I had no idea of anyone else's involvement.
Well, it had been made on a promise job, hadn't it? You entered into the case log, so that's how you came to see it on the daily intel sheet.
Yes.
So anyone could have relayed it up the chain of command, correct?
Correct, which is what then I did.
Does the chain of command see the daily intel sheet as well?
If they look at it, I imagine there's instances where they don't look at it. I think you've seen it. Even the chain of command that ended up having looked at this job didn't look at the body-worn video and stuff like that. So there's always human error.
And you were guarding against human error by drawing it to the boss's attention, is that right?
I don't know if I was guarding against human error by doing that. I was drawing it to the boss's attention.
When you alerted Sergeant Kelly, he was also critical of the response of Han and Smith, is that right?
I can't recall his comments.
He's given evidence that he was watching it surrounded by other people, or other people were there. Do you recall watching it with him in the company of others?
Yes.
And do you recall him or anybody else who was watching the video being critical of Officers Han and Smith?
Yes, I believe so, but I can't recall any specific comments.
You certainly would have shared your view of being critical.
Not necessarily, not publicly.
Well, you certainly would have shared it with your colleagues at the police station when they were watching it.
Not necessarily.
Mr. Rob, you often, didn't you, watch body-worn video in the muster room with your colleagues?
Yes.
And you would have had no difficulty on many occasions in offering a commentary about what had gone on, various uses of force or incidents.
Yes, sometimes.
And I'm suggesting that it's likely that you offered a commentary here that was critical of Han and Smith.
I can tell you that in a public setting like a muster room with multiple police officers like that, it's likely that I wouldn't have.
Well, I think you told us earlier that there appeared to be a culture of watching body-worn videos, watching other people's body-worn videos. At least it happened on many occasions, didn't it?
Yes.
Including the video that we saw yesterday of Aralyn Park, the Woods videos that we subsequently filmed.
Yes.
So you didn't have any difficulty on that occasion in filming your body-worn video in the muster room with other people around making a commentary?
Yes, the difference here was that, again, it's a high-risk incident, life or death incident. As I've said, I'm understanding that most humans, I believe, would have responded the same way, including most police officers. Often you'll get comments in situations like this, officers saying, they would have done this, I would have done this better. You'll likely have the comment from Shane King saying, I believe he was referring to someone who had made a comment saying you'll never know what you're going to do in that situation. I agree with him. So in situations in public like that, I'm not going to get involved in I would have done this, I would have done that, because I know that most police officers and most humans would react the same way.
Well, this is what you said on the spotlight footage, 20-53 for my friends, page 2. You said, in relation to the jurors watching the example of Lanyon Smith and Chris Hand, none of them have had the training I have, the experience I have. They're just regular citizens, and they likely have never dealt with violence, with the threats upon their lives. But I've dealt with lots to the point where it's nearly normalised to me. But these regular humans, did you make a comment or any comment about the fact that police officers should have been ready to deal with that in a different way to the way Hand and Smith did?
I'm not sure if I made a comment, but I agree with that statement.
That you had been at the time you were in the Northern Territory Police Force merely normalised in relation to violence?
Yeah, I was desensitised to violence.
Desensitised to violence.
Conditioned to responding to violence.
Conditioned to respond assertively to violence.
Professionally, within the use of force guidelines.
And in circumstances where you can have a choice to respond, you opted, didn't you, usually, for the most forceful choice available to you?
I disagree with that, and I don't believe I've ever been found guilty of using excessive force by the NT Police.
No, you were never pulled up on your use of force, even though, as I pointed out to you yesterday, you had been red flagged by professional standards in relation to their concerns about your use of force.
Well, there's no evidence that he knew about professional standards. The question's unfair.
Yes.
I'll withdraw it.
Thank you.
Sergeant Kelly said this. He recalls someone saying when you watched the video that it demonstrated a lack of situational awareness. Is that you?
I don't think so.
So there were a number of people, weren't there, making comments in relation to that video in the muster room.
Yes, they could have been.
And then the text message that I took you to yesterday, 547.
Yes.
There was obviously an exchange with you and Paddy McCormack. Was he a sergeant or senior constable?
I'm not sure.
Senior constable, acting sergeant. So he's given evidence that he thinks he watched the body-worn video. He couldn't remember where he watched it. Can you remember whether you watched it with him or separately?
I can't recall.
He clearly thought it had been handled poorly and told you so. Is that right?
Yes.
And you had shared your views with him about that as well. Have you?
Well, you can see what I said.
Sure. He says, I'm sorry, I watched that, fuck me. And you say, yeah, eh? And he said, do you imagine if that other cop got killed and he stood there and watched it with his fucking hands up? What the fuck have we become? And you write back, I know, eh? Fuck my whole life. So there's you and your senior constable, acting sergeant, sharing the view that what Chris Hand and Lanyon Smith did was wrong, correct?
Correct.
And you did that without any understanding from Chris Hand or Langan Smith about what had been in their mind and why.
Apart from the version of events that I've been given, and I believe the same thing has been done against me in a number of body-worn videos in this instance, in the Coronial. 8 or 9, and it was done so in the trial.
The only version that you had was from the promise note, correct?
The summary version of events that was on the promise case, which could have been multiple paragraphs.
Sorry, I just didn't hear that.
Sorry, it could have been multiple paragraphs.
Thank you.
Can you remember any of it now?
I can remember the thing that made me more curious about it was something to do with the fact that they approached the offender at the back of the house, and he was in the back bedroom, and he escaped through a door, but I couldn't understand how that if he was in a back bedroom, how he escaped through a door, something like that.
You couldn't understand it, and so you thought you still had enough evidence or enough information to assess it in a critical way. That's clear, isn't it?
There was more information than that given, obviously, in that. But that's what made me go into the case log and watch the body-worn footage so I could get a further understanding of what the assault was.
You called Sergeant Bowens, who was off duty, and you told him that it was a job that the IRT should have already been called out for.
Potentially.
It was a potential job that the IRT should have been called out for. Is that what you said?
I believe so.
Your patrol group went looking for Kumanjayi at Walpuri Camp, is that right?
Yes.
And that was because you were proactive about it and found the job?
That was, I guess, we had a downtime in between jobs that we were being called to, and we would often then look for active arrest targets, and he was one of them.
Had you gone out to look for him separately yourself?
I believe Hanson and I had.
In what circumstances?
You have the information before you, and you have it better than me.
Mr. Robb, I'm asking you a question, and you're under oath, and you're obliged to answer my questions in the absence of an objection.
I can't recall.
In what circumstances did you go and look for Mr. Walker, except for your trial group?
I cannot recall.
You recall that you were with Mitch Hanson, at least, is that right?
Well, I recall that from the evidence that I've read.
All right. Evidence that you've read at trial or elsewhere?
Trial or coronial. I can't recall.
And did you do that before or after your patrol group went to look for Kumanjayi at Walpuri Camp?
I cannot recall.
Is it the case that you were proactive with Constable Hanson in the two of you searching for Kumanjayi Walker, either before or after your patrol group went to Walpuri Camp?
I cannot recall. If I couldn't recall before, I can't recall specifics of the answer.
Just listen carefully to the question. You've given an answer, I think, that you and Constable Mitch Hanson looked for Kumanjayi Walker separately to an occasion where you were with the
Yes.
patrol group. And you can't remember whether that was before or after you were with the patrol group.
Correct.
And you're inviting me as counsel assisting to look at the evidence myself and try and work that out. Is that right? I'm not being critical of you. I'm trying to understand.
Does it
your
matter
answer.
what he's inviting?
I'll move on.
Thank you.
You're saying that you can't remember either way, whether it was before or after the trip to Walpuri Camp with your patrol group, but there was a separate occasion where you looked for Kumanjayi Walker with Mitch Hanson.
Yes.
And that's an example of your proactivity about that job, correct?
I was proactive. I was a proactive police officer.
When you went to the Walpuri Camp with your patrol group, there was a car bonnet briefing in the Bunnings car park, correct?
Correct.
You had 7 officers with you, I think, at that time, or there were 7 officers. Kirstenfeld, Hanson, Boney, Crotty, King, Sergeant Kelly and yourself, is that right?
I accept that.
And you did the briefing on that occasion?
Yes.
You've described that as a SMEAC briefing, situation, mission, execution, admin and logistics and command signals.
Yes.
It was necessary to prepare that briefing.
Logistics. Oh, yeah, admin logistics, yes.
Admin and logistics. It was necessary to prepare that briefing because you knew you were dealing with a high-risk offender, correct?
Yes, and I believe there had been some talk around the station potentially that they wanted us to start doing briefings like that and potentially putting them on body-worn video.
Well, it made sense, didn't it, to have a briefing where you made an assessment of the risk that the group were facing in terms of that arrest and
Yes.
planned for it.
Yes,
That's in line with your training, isn't it?
yes.
And this is how you characterise Kumanjayi at trial,
So what page?
1040. How did you characterise him in your mind, at least? You're asked by your counsel. I characterised him as a high-risk offender, extremely violent, who was willing to use lethal weapons against police. That's your characterisation of him on the 7th of November, and that was your characterisation of him on the 9th of November.
Will I object to any questions about the 9th of November?
Yes, Mr Abbott?
On the grounds that the answers may tend to incriminate him. Section 38, subsection 1B. 1A
Yes.
rather.
Yes.
The
Mr.
objection was foreshadowed. I understand the position to be Mr. Wolf, that Your Honour should consider it expedient to increase the justice that was involved on providing the certificate. I understand the position to be with respect to the first shot, which was not the subject of the indictment for not, Mr. Wolf could be objecting for the prosecution. And on that basis,
Could be.
we can see that there are reasonable grounds to suppose that his innocence is continued.
Yes. Thank you for raising that matter, Mr Abbott, and I do find it
Your Honour,
expedient.
we wish to be heard whether it is expedient. We say, Your Honour, he should, having declined to answer the question, no certificate should be issued, and his refusal should stand, and his refusal to answer any questions about the 9th of November should stand in relation to all and any questions. Given what we know about the interests of the other parties here, and in particular I refer to NAJAR and the Human Rights Law Centre, which apparently have already taken proceedings. And we say, Your Honour, that you probably don't know about the agenda they have, but we say, Your Honour, that my client, the answers that he gives, if he's required to answer because you give a certificate, can be used in a derivative way. Although the answers can't be directly used, they can be, any derivative use is not barred by Section 38. And Mr Bolton, my learned friend Mr Bolton, has already said and made it clear that his position, he said at page 348, the verdict only relates to those two shots. The verdict does not relate directly to the first shot, to the decision to enter the premises, to arrest, to detain, to deploy the IIT, and so on and so forth. So, if my client is forced to answer these questions because you come to the view that it is expedient that he be compelled and offer a certificate, then derivative use can be made of his answers, and my client may find himself in proceedings where he has already given evidence, not only at trial but also in these proceedings, and he has committed himself to a position which those who bring the proceedings are fully aware of course, because they will have the transcript. So we say, in interest of fairness, he should, having asserted a right, the right he has not to incriminate himself, he should not find it expedient that he be compelled, and his refusal and declining to answer questions should stand, in relation to each and every question in relation to the 9th of November 2019. I refer you to the NAJAR submissions this February. Again, Millennium Mr. Bolton's submissions, he referred appropriately to section 38, and he said, we submit that once the right against self-incrimination is abrogated, the Parliament did not intend that any further additional consideration should be given to this right. As per our submission above, the second reading speech to the Coroner's Amendment Bill 2001 shows the Parliament's particular premium on ensuring that incriminating questions are asked in full contemplation that the answers might lead to a prosecution. So, Mr. Bolton, Millennium Mr. Bolton knows that this is the consequence, potential consequence, if my client is now forced to answer further questions about the 9th of November. And, of course, there are other actions that have been taken by the families, civil actions, but my client should not be forced to again go over the events of 9/11, given what is obviously contemplated by those who act for the families, by those who act for NAJAR, and for the, presumably, the possible consequences for him. Your Honour also said this in your ruling number 2. I'm reading from paragraph, I think it's number 2, paragraph 41. Your Honour said, ultimately, provided I do not include in a finding or comment a statement that a person is or may be guilty of an offence, Your Honour is referring there to section 34, subsection 3, it does not controvert an acquittal for a coroner to inquire into the facts underlying an offence of which a person has been acquitted. Your Honour was dealing with whether or not the acquittal was a bar to any evidence being given in these proceedings. Your Honour, I want to say, in any event, as Mr. Bolton, SC, submitted in oral argument, even if the verdict of acquittal somehow set parameters for fact-finding during the inquest, there could only be in respect of the second and third shots fired by Constable Rolfe, because only those shots were the subject of the charges which Constable Rolfe was acquitted. And Your Honour referred to the transcript of the 12th of September 2022, and I think that's a mistake, the paragraph reference, the page reference.
You think it should be the page that you referred to?
348.
Thank you.
Yes. But accepting that, so I won't read page 300, what my learned friend Mr. Bolton said at page 348 again. My learned friend Mr. Bolton did say in his February submissions on behalf of NAJAR at paragraph 45, if there's a concern that
Sorry, just let me find that. Sorry, I do have it here. Yes, thank you.
The learned friend Mr. Bolton said if there's a concern about the open publication of that the open publication of Mr. Rolfe's evidence might prejudice a future fair trial, as outlined in the second reading speech, the Act allows the coroner to suppress that evidence. So the learned friend Mr. Bolton and those for whom he acts or at least those for whom he acts, clearly have in mind the prospect of a future trial in relation to not just the first shot, but presumably the other matters that have been raised. How that may come to pass, we don't know. But all I'm saying, Your Honour, is that this matter, so far as some of those interests who are represented at the bar table are concerned, some of those interests obviously have taken action, intend to take action, and will take action in some way, shape or form in relation to proceedings that involve my client. And given that we don't know the nature and extent of all these proceedings, for example, I'm told, Your Honour, this is hearsay on my part, that there's already a writ issued in the Darwin Supreme Court in relation to these matters, a sort of holding writ until this coronial inquest is finished. I haven't seen it, so we can't obtain it, of course, because we're not parties to it. But these are and they're human rights applications on behalf of 3 of the persons named in the use of force matters. So there's a series of litigation, the extent of which we don't know because no one's told us. We've had to try and find out for ourselves, which involve or potentially involve my client, and which would utilise, if not directly then indirectly, the answers that he gives in relation to the events of 9/11/2019. And for all those reasons, my client declines to answer any question in relation to that date, on the ground that his answer will or may tend to incriminate him in some way, shape or form. And in our respectful submission, it's not expedient for the purposes of justice that he be compelled. Yes, and Your Honour has the trial evidence, which we submit is quite sufficient for you to discharge your functions.
Yes, thank you.
I might start by observing while we had notice that an application for an objection was taken, we had no notice that the position Mr. Roth would be that Your Honour will not compel him, and nor was this an objection identifying the intended client to be brought in advance of the hearing. Notwithstanding those matters in my respectful submission, and due regard to the concerns raised by this matter, Your Honour will dispatch of the matter relatively swiftly. I just start by acknowledging 2 considerations that we must take into account as urged by Mr. Abbott. They are the possibility of liability for the offence of murder or another offence of violence associated with the first shot, besides the possibility, and the seriousness of those offences. They are relevant considerations that one must have regard to. Your Honour must have regard to the value that the common law has placed on privilege and self-incrimination. And Your Honour must have regard to the fact that the certificate you issue under Section 38 affords Mr. Roth direct use of the and knowledge of the use. Nevertheless, the balance of considerations powerfully weigh in favour of compelling Mr. Roth. The first can be defined from the purpose of Section 38 itself, which was inserted into the Crimes Act in 2002 by discrete amendment for the sole and express purpose of ensuring that coronial proceedings are not frustrated by witnesses who refuse to give evidence, and that the coronial objectives of getting to the truth and preventing loss of life are not frustrated. Second, while we concede that it is possible that there could be liability in criminal law for the first shot, it is, as a matter of law and practice, extraordinarily unlikely that there would be a prosecution of that. Your Honour, Mr. Rolfe has an absolute bar in the Northern Territory in respect of the second and third shot, and would have a persuasive argument prosecution in respect of the first shot should not proceed. Your Honour doesn't need to delve any more into that possibility, but it would be wrong for Your Honour to conclude that there is a likelihood of prosecution. Third, there is a direct use immunity certificate, and with respect, the prospect of Mr. Rolfe suffering some derivative use is artificial. Your Honour will recall, this is not a case in which Mr. Rolfe is about to identify, or that there's any likelihood that he will identify other sources of evidence that investigators could go and obtain. Really, the only matters he's going to be giving evidence about are his own views of his own conduct in his state of mind. That evidence will not be available in the prosecution, and it is really difficult to see what derivative use could be made. The second point, and this is in relation to Mr. Abbott's comment that Mr. Rolfe will somehow be locked into a version and will thereafter be known to the world what his version of events will be, it's just absurd. He gave evidence at the criminal trial. His version is out there. Forevermore, it is admissible in a criminal court against him. And it's just fanciful to suggest, unless Mr. Abbott knows something we don't know, that Mr. Rolfe is about to be locked into a version of events that just wasn't provided at the trial. The fifth point I'd make, Your Honour, is in relation to the spectre of civil proceedings. The direct use immunity certificate under Section 13 extends to such proceedings, but a concern that those proceedings might be brought is no longer in the Northern Territory a proper basis to object under Section 38. Your Honour ruled that it was, but on Mr. Rolfe's appeal to the Northern Territory, Your Honour was overturned in that regard, and now the law is that Section 38 only recognises a claim of privilege against self-incrimination. And so, in my respectful submission, it really is by the by that there might be some Racial Discrimination Act proceeding, for example, in another court. Finally, Your Honour, it's not for me to speak on behalf of Mr. Bolton or Narjana,
which I'd like to do.
but certainly we divine nothing in the transcript of Mr. Bolton's remarks about the legal operation of Section 38 that flagged an intention on the part of any party at the bar table to take subsequent legal action. So for those submissions, Your Honour, we respectfully submit that it is expedient in the administration of justice for Mr. Bolton to go down.
Your Honour, there's one matter that I haven't mentioned that I must, on behalf of my client. The DPP made a concession at trial that the first shot discharged by my client was fired in self-defence. That was a concession made with full knowledge of all the circumstances, and as a consequence of reports which the DPP had received from experts. I won't go into those reports, Your Honour, I'm sure those have read them in far more detail than I have. That was a decision made by, as the learned friend, Counsel Assisting has said, an independent body, the Director of Public Prosecutions, transmitted to their counsel, Mr. Strickland, and made not just at trial, but I understand in other areas, but in any event formed part of His Honour Justice Burns' summing up, and also in relation to his rulings. It's most conveniently found in the Queen and Rolfe number 7, 2022, NTSC 1, at paragraph 110, where His Honour said, the decision by the accused to fire the second and third shots was made on the Crown case within a period of 2 seconds. The deceased had produced a weapon and used that weapon to wound the accused, and had then continued to struggle with Constable Herbal while still in possession of that weapon. It is accepted by the Crown that the first shot discharged by the accused was fired in self-defence, such that the decision by the accused to discharge the second and third shots came after the legitimate use by him of his firearm in self-defence against the deceased. In addition, the accused had been briefed about the violent tendencies of the deceased. I won't read any more, but I ask, because it would assist my argument, whether there's any intention by counsel assisting or anyone else to challenge the acceptance by the Crown that the first shot was fired in self-defence. Should you give a certificate and should cross-examination then proceed, are we going to get into a situation where, despite the full knowledge that the independent authority, the DPP, had, and to accept and make the concession that the first shot was fired in self-defence, are we going to get into a situation where that is going to be challenged by your counsel assisting and by other members here at the bar table? If so, in my submission, that's a further matter of great consideration and weight that Your Honour should take into account.
Briefly on that final point. You still got this?
No.
Briefly on that final point, the short answer is I don't know whether that would be explored. It would be, in my respectful submission, appropriate for the law to require of the parties as to how they intend to cross-examine Mr. Rolfe on the grounds. But for the purposes of argument, Your Honour should assume that it may occur so that Your Honour doesn't need to make the inquiry. But nevertheless, the balance of all considerations of recognising that there is a near possibility of prosecution of this kind and that a direct use of the certificate will be granted, given the significance of this evidence, when does it expected to be administration of justice?
Well, Your Honour, that leads us into a situation of comity. Your Honour, I say this with respect, is sitting as in an executive capacity
Yes.
as a persona designata. We're dealing with a concession made by one member of the executive, namely the DPP, at a trial, and Your Honour must pay. I don't make the submission, Your Honour, bound by it, but Your Honour must pay great respect to it. It would be quite wrong, because the government is one and indivisible. So you are sitting today as one arm of the Northern Territory government, and if this matter is raised, sorry, Your Honour's shaking your head as I.
I'm sitting as the coroner in an inquest.
Yes.
I'm not sitting as an arm of government.
Well, you're sitting as a member of the executive of the government, albeit as a persona designata, and it's, we say, obligatory upon Your Honour to give full force and effect to another decision of the executive, which has been made and which is quite clear and made on a proper basis. It can't be said to be irrational or irresponsible for that decision to have been made. So these are considerations that you need to take into account, I say with respect, when responding to a learned friend who suggests, whose submission is that you should give a certificate.
Could I just say a few things, please?
Yes, Mr. Bolton.
Just to set the factual basis straight about this application. I represent Narjar. Narjar is here in its institutional existence. I do not represent clients of Narjar, past or present. Narjar has acted for a number of people who made complaints about Mr. Rolfe's conduct. The complaints were made to the Australian Human Rights Commission. They did not relate to the events of the shooting of Kumanjayi Walker. They related to a number of incidents that have been the subject of extensive questioning in the course of the inquest, including yesterday and on Monday, as Mr Abbott described them, some use of force incidents that occurred in the years leading up to the events that are central to the consideration of the inquest. Those proceedings are concluded. They have all been discontinued, as I understand it. As Your Honour is fully aware, NAJA does not act for the families of Kumanjayi Walker. We do not act for any association based in Yuendamu, and we don't act for the Barumpa Group Committee. NAJA has not instituted any proceedings on behalf of any client in the Supreme Court of the Northern Territory or in any other court on behalf of anyone who has a complaint about the events surrounding the death of Kumanjayi Walker. If there is on foot some proceedings, they have nothing to do with NAJA. Having laid that factual foundation, I simply rest on the submissions that I advanced a long time ago and which have been quoted in detail by Mr Abbott today. Everything that I submitted then, I stand by. It's all correct. I also remind Your Honour, as Mr Coleridge has done, that the Court of Appeal has now made apparent that there can be no claim for privilege for any exposure to a civil penalty. And dare I say it, a position that NAJA advanced before Your Honour to contradict every single other party in this room and the Northern Territory government eventually. So the fact of the matter is that when Your Honour needs to consider whether or not to issue this certificate, there is little, if any, exposure that we're aware of that might lead to the current witness being ordered to pay compensation or act in a particular way. There might be, but it's got nothing to do with us if there is. But even if there is, that is not a very strong basis to refuse to issue a certificate when the basis for the claim in this case is a claim for privilege against self-incrimination. This is sort of a backdoor way of trying to get around the issuing of a certificate on the basis of a claim for the claim of privilege against self-incrimination. I might not be really exposed to criminal prosecution, but we've heard somewhere someone has some sort of civil claim against me or might. And that's really where we're at the moment, it seems. So, the last thing I would say is an extremely obvious thing, there are two things. They're both extremely obvious. First, what Mr. Coleridge says is absolutely, totally irrefutable. There is but the merest theoretical possibility, a textbook possibility, an exam question possibility, that Zachary Rolfe might walk out of this Coronial inquest and one day be charged with the first shot. We all know that is entirely unlikely to happen in this real world. It's a theoretical possibility, which is every reason why you should grant the certificate, not grant the certificate. Secondly, the fact that the Director of Public Prosecutions, on the evidence available to him at one time, made a concession in a trial, does not bind you, nor this court, in any way about any decision that you need to make here now. To be blunt, the concept of comity between you and the Director of Public Prosecutions is a nonsense.
Your Honour, may you hear the family on three brief points.
Yes.
Firstly, the Brown family supports the submissions of Mr. Bolton and counsel assisting. Secondly, again stating a proposition that might otherwise be obvious, it is not entirely clear what worse position is Mr. Rolfe is in with the inquest occurring after the criminal trial than before the criminal trial. Had the inquest occurred before the criminal trial, he would have had exposure to prosecution for the entirety of the events. He would have applied for a Section 38 certificate and been granted it. It's not clear why he is in any worse position now, if in fact not in a better position, having been acquitted of the second and third shot, with the only exposure, as Mr. Bolton has explained, being the technical exposure to a prosecution in respect of the first shot. The third issue is that in terms of expediency and weighing the various considerations that Your Honour must address, getting to the truth of in fact what happened with the additional material that is now available is a very important factor that the families believe Your Honour should take into account.
Thank you. Mr. Bowe?
Right, just one further matter in our submission, Your Honour, should take into account in determining whether you should offer to Mr. Rolfe a certificate is that this claim for privilege is being made not only after Mr. Rolfe giving evidence at the criminal trial, but following upon his waiving privilege in giving interviews to the Australian newspaper in May 2019 and further in his subsequent interviews which have been published in the Spotlight program. One looks at the transcript of the interview with the Australian newspaper, he goes into chapter and verse to give his version of events concerning the events of 9 November. And before I sit down, I'll just mention as a matter of courtesy that whilst we've been debating that the maternal grandparents of Kumanjayi Walker, Mr. Joseph Lane and Ms. Annie Lane, have been sitting and listening.
Thank you. Dr. Freckleton.
Thank you, Your Honour. We shall be very brief. We concur with the position adopted by counsel assisting and say that Your Honour ought to require answers in respect to events on the 9th of November.
Your Honour, just to be clear, the Parent Group Committee, it's not engaged in any litigation of any kind except presence at this inquest. Adopted submissions of counsel assisting Mr. Bolton, Mr. Mullins, Mr. Bowe. The steps Your Honour should take are those which are going to lead to get to the truth of the matter. That finalise the granting certificate. Then it's
Well, Your Honour, I haven't heard any of the learned counsel who addressed you respond to my statement that we have heard that there is a writ in existence. I don't say that that's the be-all and end-all, but it's a circumstance that you should know about and should take into account when exercising your powers under Section 38. If there is no writ, and everyone says there's no writ, then that's one thing. But as I said, it's come to our attention that there are some proceedings on foot that we do not know about that involve either the government of the Northern Territory and the police force, or one or the other, and that the proceedings involve not just at least the events of the 9th of November 2019. So if no one knows about it and it's all a secret and it doesn't exist, then I want to be told.
Well, I've already said it. It's not nothing to do with us.
Your Honour, my respectful submissions, it's for one member at the bar table to make interrogatories of other counsel at the bar table. To deal with the application, Your Honour should simply assume that there is such a writ, identified as a relevant consideration for the reasons identified in Mr. Bolt, give them merit of the weight in most consideration. Section 38 is not and immunity from civil
Thank you. I'll now take the morning tea adjournment.
Stand. Coronial Court's case temporarily adjourned. Coronial Court's now resumed. Please be seated.
Mr. Rolfe has objected to giving evidence concerning the events of 9 November 2019 on the basis that his answers may tend to criminate or incriminate him. Mr. Abbott acknowledges that the objection is to be determined under Section 38 of the Coroners Act. I will not set out that section, but note that it permits a witness to object to answering questions on the basis that their answers may tend to criminate them. Where an objection is made, I may offer a certificate under Section 38 if I am satisfied it is expedient for the purposes of justice to do so. Once offered a certificate, a witness is no longer entitled to refuse to answer the questions on the grounds of privilege. Mr. Abbott objects on the basis that Mr. Rolfe could, in theory, be prosecuted for an offence arising from the events of 9 November 2019, such as the firing of the first shot, or potentially in respect of some other action or omission on the 9th of November 2019. I accept that this is theoretically possible. Even so, I am satisfied that it is expedient for the purposes of justice to compel Mr. Rolfe to answer the questions about the 9th of November 2019. Because, firstly, although I accept there is a theoretical possibility of prosecution for a very serious offence, I consider that possibility is remote. 2, the certificate grants Mr. Rolfe an immunity over the use of any answers he might give. 3, while I accept the certificate does not prevent derivative use, any prejudice that might arise from derivative use is hard to identify, given his previous sworn evidence at trial about the events of 9 November 2019 and other accounts that Mr. Rolfe has already provided about that day. 4, Mr. Abbott raised the possibility that civil action could be taken against Mr. Rolfe. Assuming that is so, it is hard to see how that is a proper basis for an objection in light of the decision in Rolfe and the Territory Coroner. And while I take it into account, I give it little weight. Finally, while I accept that the privilege against self-incrimination is a long-standing right, Section 38 partially abrogates that right, specifically for the purpose of getting to the truth in coronial proceedings. For those reasons, I now offer Mr. Rolfe a certificate under Section 38 concerning the events of 9 November 2019, noting that these reasons have been given on short notice.
Thank you, Anna. Mr. Rolfe, at trial in relation to the 7th of November, you said that the combination of the information you had informed you as to how you would characterise him as a potential risk to police officers. Do you recall that evidence?
Recall that was the effect.
All right, I'll just read it to you. It's transcript 1040. You asked a question, how did you characterise him in your mind at least? And you said, I characterised him as a high-risk offender, extremely violent, who was willing to use potentially lethal weapons against police.
Correct.
And that's how you characterised him on the 9th of November. I mean, nothing had happened in between to change your characterisation of him, had it?
Correct.
The briefing that you gave or participated in with other officers on the 7th of November was important to try and properly prepare to address the risk?
Correct.
Kumanjayi was in fact not at Walpree Camp on the 7th of November, and you then found out from that Sergeant Frost had intel that he was still at Windermere.
Correct.
On the 8th of November, you again accessed the body-worn video of Hand and Smith on multiple occasions to show your colleagues at the police station in Alice Springs.
I accept that.
You wanted to make them aware of what had happened on the 6th of November and alert to this offender.
Correct.
And no doubt that was important. Did you also take the opportunity to share your views about the response of Hand and Smith?
I don't believe so.
On the 9th of November, about 2:30 p.m, you received a phone call from Sergeant Shane McCormack.
Correct.
I asked you earlier whether or not he was the acting officer in charge of the IRT at times because Sergeant Bowles was on duty. On leave, not on duty, he was off duty. Did you recognise Sergeant McCormack at any stage as the acting or de facto head of IRT if Sergeant Bowles was off duty?
Yes, I said I just wouldn't have thought of those in those words.
Okay.
Correct, like I would have thought 2IC.
All right, so that's how you describe Sergeant Shane McCormack. He's the 2IC of the IRT.
Correct. In that time frame.
All right. And so Sergeant Bowens was the OIC and then McCormack was the 2IC, is that right?
Correct, at that time.
Okay. So it made sense though that he was giving you a call in relation to the IRT briefing.
Yes.
Regarding your move. On previous occasions when you had deployed with the IRT, was there a team leader appointed?
Yes.
And on previous occasions when you deployed with the IRT, was Sergeant Bowens always with you?
I can't recall.
When Sergeant Bowens was with you on an IRT job, he would be the team leader, is that right?
Yes.
And if Sergeant McCormack was with you instead of Bowens, would he be the team leader as the OIC? 2IC, I should say.
Yes, he would have been. If Luke Bevan was there, he may have been. But yes.
Had you ever been the team leader of the OIC? Sorry, a team leader of the IRT on any jobs?
I can't recall, probably not officially.
Unofficially nominated as the team leader, is that right?
Perhaps.
You just can't recall something. But
Yes.
there certainly had to be a team leader, didn't there, on previous IRT jobs?
Yes.
You were told on this occasion that the mission was to arrest Kumanjayi Walker,
Yes.
and that made sense to you because you thought yourself that the IRT might be involved in a job like that.
Yes.
Did Sergeant McCormack tell you who the team leader was?
No.
You got to the station and Sergeant McCormack was there to give a short briefing, is that right? Sorry, I'm talking about Alice Springs Station. Did you see Sergeant McCormack again or not?
Yes, I did.
Was he at Alice Springs Station?
Yes.
And he provided a short briefing consistent with the idea that it was the major brief was to arrest Kumanjayi Walker, is that right?
I believe he told me we are going out to Yuendamu to arrest Kumanjayi Walker. We would get to Yuendamu and Frost would give us more information.
Sorry, I just didn't hear that.
We'd get to Yuendamu and Frost would give us more information. Is that what you said?
Yes.
At trial, you explained that you were told by Sergeant McCormack at the station that the IRT would be you, Kirstenfeld, Eberl, Hawkins and Adam Donaldson, the dog handler, correct?
Adam Donaldson was not IRT. He would be an attachment.
The dog handler, is that right?
Correct.
You understood him to perform that role.
Correct.
You were told that the nurses had experienced break-ins and had left.
I'm not sure when I was made aware of that, but it would make sense that I was told that at the station.
And you were expected to drive to Yuendamu and hopefully get further intelligence from Sergeant Frost at the time.
Yes, further instructions.
Were you told who the team leader would be?
No, I was not.
The first briefing in Alice Springs Station by Sergeant McCormack, was that just you with McCormack?
Yes, I believe so.
You arrived first, didn't you, to respond to the job?
Yes.
Were you expecting that Sergeant McCormack would come out with you on the job?
No.
Were you expecting that at some stage a team leader would be nominated?
Not necessarily.
In the absence of a formal team leader being nominated, you assumed that role de facto. Is that fair?
I feel the leadership vacuum, yes.
Before departing, you spoke to the other 3 IRT members, Kirstenfeld, Ebel and Hawkins, about what the mission was.
Yes.
And essentially it was to arrest Kumanjayi Walker.
Yes.
And you repeated some of the aspects that you've been told by Sergeant McCormack, Paddy McCormack, is that right?
Yes.
In the Alice Springs Police Station, you played the body-worn video of Chris Hand and Namian Smith, the so-called axe incident, is that right?
Yes.
And you were there for about half an hour, I think, before you left and went to Yundamur, is that right?
I'd accept that.
Did you tell them anything about Kumanjayi's previous criminal history?
I can't recall.
You made it clear to them, did you, that in your mind you characterised him as a high-risk offender
I would accept that.
and extremely violent, someone who was willing to use lethal weapons against police?
I would accept that.
And you were critical, weren't you, when you showed them the body-worn video of what Hand and Smith's reaction had been?
As per my previous answers, yes.
You and Officer Kirstenfeld left separately. The CCTV shows that you arrived at Yundamur at 6:33 p.m, correct?
Correct.
Now, as you know, because you've been shown this document on a number of occasions in previous proceedings, or I'm sure that you've been shown this document on a number of occasions during the trial, you are aware that an arrest plan was sent by email at 4:59 p.m. from Julie Frost to yourself and others.
I know the email you're speaking about. I disagree that it's an arrest plan.
You were sent an email, weren't you, by Sergeant
Yes.
Frost? I'll just give you a copy of that. It's Exhibit 14 for those at the bar table. It's in the briefing evidence. I don't have a copy for you, sorry. Just how I know you've looked at this document a lot. Just refresh your memory from it if you don't mind. You've seen that document many times before, Mr. Roll.
Yes.
Your evidence is clear that you did not receive this email prior to getting on the road to drive out to Yundamur.
Yes.
And that's because you were focused on driving out, is that right?
There's no reception between Alice Springs and Yundamur.
Okay. And you say when you arrived at Yundamur, you certainly had your phone, is that right?
I have my personal phone that doesn't have work email.
Sure. When you got to Yundamur, were you anticipating, or I withdraw that, you were anticipating, I think, further instructions from Sergeant Frost, correct?
Correct.
The CCTV footage shows the time that you arrived at Yundamur, about 6:33 p.m. And you and Constable Kirstenfeld obviously spoke to Sergeant Frost over that period of time before Ebel and Hawkins arrived, correct?
Correct.
There's about 20 minutes or so before they arrived, do you understand that?
Yes.
And during that time, Sergeant Frost wanted you to wait, didn't she, until the other officers got there before she spoke to you further about what the plan was?
I can't recall that. I'd have to refer to my trial evidence.
So sitting in the witness box there, you can't recall whether or not she asked you to wait, is that right?
I can't recall that.
Can you recall the demeanour of Constable Kirstenfeld in that conversation with Sergeant Frost?
Yes.
Just think back to Constable Kirstenfeld and his demeanour. And his demeanour generally, when he was talking to people in a work situation, he could easily come across as overbearing.
He could. I don't believe he was in that situation at all.
He could come up, you know Jimmy Kirsterfeld. You can
Yes.
take it from me that we have, as a court, seen the video in relation to him dealing with Antonio Woods after he was arrested. It would be fair to describe Constable Kirsterfeld, with no disrespect, as intense.
Sometimes he can be.
Can I suggest to you that on this occasion, when he wanted information from Sergeant Frost, he was intense?
I would disagree. He was. From what I saw when I was in the room with him, he was professional. As you know, there are some people that can come across as in a more difficult way. Jimmy can be one of those people. In this instance, from what I saw, given that I've worked with him for a long time, he seemed professional to me.
He took the lead in that conversation with Sergeant Frost, didn't he?
I actually disagree.
He was wanting answers from her about what the mission was, further details about what the mission was.
In my recollection, I took the lead.
What do you remember about the conversation that you had with Sergeant Frost before the other officers arrived?
Julie Frost told me that she wanted us to arrest Arnold Walker at 5 a.m. I asked her where he was going to be at 5 a.m. She said she had no idea. And I said was the effect of, in order to make a plan for an arrest plan, we need more intelligence than that. And we will need to go and gather intelligence.
While you were speaking to Sergeant Frost at Yundamoo, she pointed to a folded document which contained that email that I just showed you, didn't she?
She, as per my trial evidence, pointed out a corner of one of the pages with houses of interest on it.
She said to you that that was a plan in relation to the arrest, or words to that effect, didn't she?
No.
I ask you to have a look at this, please. It's the video compilation of the Yundamoo Police Station, CCTV from 7:05 p.m. Mr. Roth, you've had plenty of time to think about this video and you've been shown it many times previously, haven't you?
Maybe in the trial a couple of times.
Have you seen it again in preparation for your evidence today?
No.
Do you need to see it again now?
No.
It's clear I can remind you that that's a period of time after Ebel and Hawkins have arrived, and it's another part of the briefing from Sergeant Frost.
Yes. Oh, no, I disagree with that.
You don't think it was part of the briefing?
The briefing that was given at that point in time was ran by me.
Alright.
I should have added to the end of that answer when I gave Julie Frost my view that we needed more intel. She agreed with me, and I told her how IRT would generally do this. In this situation, we would go into the community, introduce ourselves to the community. This is as per my trial evidence. Let them know who we were, what we were there for, and seek to gain community assistance in order to achieve our task. And she agreed with me. The briefing that was given for all 4 boys was ran by me, in her presence.
Okay. The video, I'm told, unfortunately stopped working. Can we do that again? Sorry, you didn't get to see the whole of the video. I wanted to show it to you. Did you just say, Mr. Rolfe, just while that video is coming up, that you explained to Sergeant Frost that one way that you would gather further intelligence is to do community engagement?
Just how I explained it then.
What was it? Sorry, would you repeat?
That we would introduce ourselves to the community, that we would let the community know why we were there and who we were, and seek to obtain their cooperation with while we were there, ideally with local members attached to us.
Do you think it was a bit funny that you'd conduct some community engagement by introducing yourself to others, letting the community know you were there, seeking to obtain their cooperation, while one officer was carrying a long-armed firearm and the other was having a beanbag rifle in their hands? That might impede on your community engagement until then.
I did not.
So what do we need to do?
You want to have a look at Exhibit 10 as an alternative.
Another alternative is to take the lunch break now until 1:30.
Yes, thank you.
We'll adjourn.
Stand.